Certainly. These cases illustrate a legal principle often referred to as the doctrine of in pari delicto, which means in equal fault. It bars a plaintiff from recovering damages if they engaged in wrongdoing related to the matter at hand. The reasoning behind this doctrine is that courts should not reward or assist a party who seeks to profit from their own misconduct. 1. Pinter v. Dahl, 486 U.S. 622, 1988. This case involved allegations of securities fraud, where the court held that a plaintiff's recovery could be barred if they engaged in wrongful conduct. In Pinter, the Supreme Court emphasized that courts should not allow a plaintiff to benefit from illegal or unethical actions, as doing so would undermine the integrity of the legal system. Example assertion in a legal filing. If you're alleging that the plaintiff engaged in wrongful conduct and should be barred from recovering, you would assert something like the following. Argument. Plaintiff's claims for relief are barred under the doctrine of in pari delicto because the plaintiff engaged in wrongful conduct directly related to the subject matter of this action. The United States Supreme Court in Pinter v. Dahl, 486 U.S. 622, 1988, established that recovery may be denied to a party that has participated in wrongdoing. In this case, plaintiff's specific misconduct, e.g., intentional misrepresentation, fraud, or illegal behavior, contributed directly to the circumstances under which this dispute arises, and as such, plaintiff cannot now seek the assistance of this court to profit from those actions. Supporting evidence. Exhibit A. Emails or text messages showing the plaintiff's intent to defraud. Exhibit B. Contracts or documents that reflect inconsistencies in the plaintiff's representations. Exhibit C. Affidavits or witness statements supporting the claim of plaintiff's misconduct. 2. Ross v. Bolton, 904 F2D 819, 1990. This case further reinforced the principle that courts should not help a plaintiff recover if they seek to profit from their own wrongdoing. It underscores the idea that equity prevents a party from using the judicial process to further wrongful gains. Example assertion in a legal filing. Here's how you might apply this to a case where the plaintiff's actions were fraudulent. Argument. Under the principles of equity, a plaintiff should not profit from their wrongdoing. As held in Ross v. Bolton, 904 F2D 819, 824, 2D 1990, the doctrine of in pari delicto prevents courts from providing relief to a plaintiff who seeks to benefit from their own misconduct. In the present case, plaintiff has detailed misconduct, which renders their claims for relief inequitable and legally untenable. Supporting evidence. Exhibit D, a sworn statement or affidavit documenting the plaintiff's fraudulent actions. Exhibit E, a forensic accounting report or financial documentation showing that the plaintiff's misdeeds directly led to the damages they now seek to recover. Recorded communications or statements that contradict the plaintiff's claims or reveal an intent to deceive. Example of how to support the allegations. In asserting these claims, the defendant U would provide documentation or witness testimony showing that the plaintiff, 1. Engaged in wrongful or fraudulent actions that directly contributed to the situation or harm for which they now seek recovery. 2. Knew about the misconduct and participated in it, making it unjust for the court to award them damages. By presenting strong evidence, such as communications showing fraudulent intent, financial records proving misconduct, or other documentation, you can build a solid defense based on these equitable doctrines. This would prevent the plaintiff from benefiting from their wrongdoing under the court's equitable powers. Yes, the doctrine of in pari delicto can also bar the recovery of attorney's fees associated with the action, especially if the plaintiff's wrongful conduct is directly tied to the legal claims being pursued. Courts may find it inequitable for a plaintiff to recover attorney's fees when they have engaged in the misconduct that led to the lawsuit. Key reasoning. 1. Equity and fairness. If the plaintiff is barred from recovering damages due to their wrongful conduct, it would also be unfair to allow them to recover attorney's fees. Since the court would not allow them to profit from their wrongdoing, it would also likely not allow the plaintiff to shift the burden of their legal expenses to the defendant. 2. Fee-shifting jurisdictions. In jurisdictions where a prevailing party can recover attorney's fees, either by statute or contract, the doctrine of in pari delicto can prevent recovery of those fees if the plaintiff's wrongful conduct contributed to the claims. Courts generally refuse to award attorney's fees to a party who engaged in fraud or illegal conduct that forms the basis of the lawsuit. Example assertion in legal filing. You could assert that the plaintiff is not entitled to recover attorney's fees as follows. Argument. Plaintiff's claims for attorney's loan fees are similarly barred under the doctrine of in pari delicto. As recognized in Pinter v. Dahl, 486 U.S. 622, 1988, and Ross v. Bolton, 904 F2 819, 2D Sir 1990, Equity does not permit a plaintiff to recover any form of compensation, including attorney's fees, when the plaintiff has engaged in wrongful conduct. Plaintiff's specific misconduct was the direct cause of this legal dispute, and as such, any request for attorney's fees should be denied in full. Supporting evidence: documentation showing that the plaintiff's misconduct caused or contributed to the dispute. Exhibit B: invoices or legal bills detailing attorney's fees being sought in relation to the wrongful conduct. By arguing that the plaintiff's wrongful conduct bars not only recovery, but also any associated attorney's fees, you reinforce the notion that a party should not benefit from wrongdoing in any way, including avoiding their legal costs.